Well, thank you everybody for showing up. Today we're talking about creating better Estoppel certificates. So that is really from my experience. I do this from kind of wearing two different types of hats. I am regularly a real estate lawyer in the city where I review Estoppel certificates. I've also on a number of occasions given presentations to the to lawyers either in the firm or to the bar generally on what to do in reviewing Estoppel certificates. And then I also work in a capacity of advising condominium corporations. So, from all of those perspectives, generally I have some ideas as to maybe how to improve things with some of those Estoppel certificates that we're running into. So I'm a partner here at Kanuka. I've been practicing law since 2005. Like I said, largely real estate and condominium law focused. You can find me either at my firm website at www.kanuka.ca or I've got a bit of a personal blog space at www.skrealestatelaw.com. That one I've maybe a little behind in terms of updating some of the content, but it's still a lot of really good stuff on there that's worth checking out if you are interested in condominiums or real estate generally. Disclaimer for this presentation. While I am a lawyer and I'm kind of commenting on these things that I'm providing this as kind of a general information. This isn't a legal advice to you as a condominium corporation. Obviously, if you're in a position where I had to advise you as a condominium corporation, I should probably do some things like conflict searches to make sure that I'm able to act for you and to learn a little more about your specific situation to determine kind of how to best apply the law to your specific situation. I'd also note to you that there's a number of reasons that maybe you won't want to disclose something in the manner that I suggest here. But if you find yourself in that situation, it's probably a good idea to get some legal advice. I think for the most part, that's not going to be the case, but I'd imagine that there's going to be a situation where maybe you have some sensitive information or you've got something that could really impact a transaction one way or the other. And you want to be very clear in terms of what your obligations are as a condominium corporation and how you should be sharing that information. I'm going to go through kind of a number of different points for tonight. The first is just to review the purpose of the Estoppel. There's some case law that talks a little bit about it. We're going to talk about what the requirements are for the Estoppel and some of those supporting documents that come as part of an Estoppel package that gets sent out to realtors and lawyers. I'm going to go through the Estoppel certificate in pretty great detail, or at least the areas of the Estoppel certificate that tend to trigger the most concern, both by me as kind of reading it and potentially as liability for you guys as the board members. And then go through some of the specific documents that are included. So financial information like budgets and financial statements, the board and Agm minutes, the reserve fund study, the insurance, the bylaws. And as a very last point, what are some kind of next level things that you guys can do to improve your Estoppel package overall? I think there's some ideas that I have that I've seen done really well, even with some different condos in the city. And I think it's probably just some things that you can think about as to whether or not it's worthwhile to improve the package that you're sending out. So looking at the Estoppel certificate, there was a decision about 15 years ago that came out in Saskatchewan. It's noted there, Little versus Condo Plan 82 S15667. That was the corporation's name. Basically, new owners came in the middle of a special assessment. There was, I think, some repairs that were due for, let's say it was the roof and then some siding repairs or something like that. They noted the one as part of the Estoppel, but they didn't note the other. And when you got to the facts of the case, it became apparent that the board probably had some inklings that there was a problem, but didn't really know that it was an issue and that was going to require kind of the remedy that ultimately ended, which was this special assessment to deal with some major repairs. The unit owners, when they came in, said, hey, we're fine paying the one thing that you, based on what you told us about, but we're not paying for this other issue that we had no idea was going to happen, or the issues that we're going to raise with that. And so they went to court and kind of disputed that obligation. The court looked at it and said essentially that the unit owners were stuck paying the special assessment. And the reason for it was that the Estoppel certificate, as they note, needs to be viewed in the context as it is a legislatively mandated financial snapshot. It is nothing more or nothing less than what it represents to be a representation of present fact and issuance date from which the owners will not be allowed to resile. So it's to certify what exists right now, and less about a probability of some outcome in the future. That is the line that the court has delineated. Where you find yourself on either side of that line would be a question on in any given circumstance, right? That's probably where, if you have a question as to whether or not we're on the line of having to disclose or not disclose, that would be the legal advice portion of it. There is a number of requirements for the Estoppel certificate provided in the legislation. Section 64 of the Act, in summary, just kind of says you need to use the form provided by the regulations. It must provide all the information provided by the form. Section 53 of the regulations then goes on to say, well, you need to follow Form GG, which is the link that I shared in the chat a couple of times. It is about an 8-page document that certifies a number of details that are important to someone who's coming into the condo corporation. And then from a fee perspective, you're allowed to charge a maximum of $200 for the Estoppel. That's section 66.1 of the regulations. There is a number of different areas that you can also charge a reasonable fee to provide certain types of documents. And I'll go through that. I think it's the next slide. But for the most part, the core of the Estoppel and what you're required to provide, $200 is the max charge. There are, like I said, a number of documents that have to be provided under the legislation. A number that must be provided, but that you can charge a reasonable fee. So on the must be provided, this includes things like a reserve fund study if it was a conversion condo. If it's not a conversion condo, then you have to provide it, but you can also charge a reasonable fee associated with that, with the protection of that. If you've got a standard unit description, you have to provide that. You have to provide an insurance certificate for the condo. You have to provide the bylaws, the current bylaws of the corporation. Any contracts that last beyond a year are listed as required. Any contracts that you may have with other condominiums. And we'll talk about that later. Copies of board and AGM minutes for the last year. We often see AGM minutes, but the board for the last year is often omitted from that package. The most recent annual return, so that filing that you do with corporations branch to denote who the directors are and all those details. The developer's reservation if common property is not complete. So if you've got a brand new condo, there's often, and even beyond that, there's often something registered against the title that's called a developer's reservation that talks about kind of how the common property is going to be dealt with. And then the bylaw compliance certificate that almost no one has is supposed to be provided under the terms of the Estoppel. Other documents that can be provided, or must be provided that you can provide a reasonable fee, like I said, the reserve fund study in a non-conversion condo, copy the budgets, copy the financials, any insurance policies versus the insurance certificate, and any management agreements that you might have. So, like I said, I'm going to go through the Estoppel certificate. I've triggered or identified some very specific sections that tend to cause the most grief for individuals. I'll go through the Estoppel bit by bit, but it is helpful to have a copy of it or up on a different screen. Also with this, I will send out to all those who are registered. I'm going to put this on YouTube as a link. You'll have an option to review the document. I'll also get the presentation as a PDF that I'll send out as well. So both of those will be available. In terms of the Estoppel certificate, so Form GG, starting right off the bat, question number 1. The corporation has passed bylaws pursuant to the Condominium Property Regulations 2001 in order to effect a reapportionment of common expenses or reserve fund contributions. If yes, describe the reapportionment. So a scheme of apportionment or reapportionment is something that, for the most part, you are statutorily required to have followed the rules and the regulations to create a formula that is different than that you are splitting condo fees in accordance with unit factors. So if you are splitting your condo fees, both your reserve fund contributions and your common expense fees, in accordance with your unit factor division or proportions, then you do not have a scheme of reapportionment. I don't think it probably matters if you, like, I've seen some bylaws where they say we have a scheme of apportionment, but it is that you split things in accordance with unit factors, which doesn't make a lot of sense, but it's fine to describe it in that phase. But you should be extremely clear as to whether or not you actually have a scheme of reapportionment or apportionment through your bylaws. Because if you don't, then effectively you are billing people in a way that's not consistent with the bylaws of your corporation and not in accordance with the Property Act. To some, this may be apparent, but I think a lot of people have created schemes of apportionment or improper schemes of apportionment within their condos in a way that they don't think of them as that. So, for example, we are billing everyone equally. We all kind of have one-bedroom condos. It's not that big of a deal. We're all gonna bill everyone equally. Well, if you've got maybe like 1 unit factor difference between all of the condos, yeah, I think there's probably a pretty minimal risk that someone's going to object to that. But if it's a larger variation than that in your unit factors, and you've just decided that that's how you're going to bill, you're probably offside the legislation, and there's some risk that can come along with that. Also, the next statement, we bill most expenses in accordance with unit factors, but some we don't. So, for example, I've seen where people will bill for kind of property management and electricity and all these other things, maybe in accordance with unit factors, but then they decide that insurance is going to be something that they split evenly between all unit owners. And again, if that's not provided in your bylaws through a scheme of apportionment, then at that point you're technically not billing or you're not sharing those fees as required by the legislation by your bylaws. Or lastly, and probably the most scary version of all of this, is those who just say, well, we kind of figured it out on our own and we just kind of made our own formula, and everyone basically agrees, so we've just decided to kind of bill it in that fashion. Again, that would be in violation of the Act, in violation of likely your bylaws. That would suggest that you shouldn't be billing in accordance to that fact. I think the only gray area that you're going to run into with this is some really old bylaws have passed what would purport to be a scheme of apportionment before maybe the regulations or the Act allowed for something like that. If they've done that, I think there would be maybe more of a question as to whether or not it would be enforceable, despite the fact the legislation didn't really contemplate it. But that would be something to look into in kind of a fact-to-fact scenario. Generally speaking, if you're passing a scheme of apportionment, you have to kind of get a super majority of, I think it's 75%. There's a whole notice process that you've got to go through to give everyone an opportunity to be advised that this is the change, and if they really feel strongly about it, they're able to dispute it to court. And at that point, once you've gone through that process, you register it with corporations branch, and at that point, it is in effect. There's lots of times where I've seen this not kind of in place. Sections 2 through 7 are largely condo fees and special assessments. kind of language. So it talks about how much your condo fees are and how, if there's a special assessment, and how you make your contributions, if they're annual or monthly or whatever the case may be. I think there's a couple of things that you should look for in this. Parking units. So parking units, if you have titled parking spots, they will have unit factors that are connected to those spots. Technically, they should be allocated a portion of your common expenses and reserve funds, just like any other unit that you might have within the development, based on the number of unit factors that they have. Now, often it's just one unit factor, so it might not make a big difference, but you should be aware of it. Secondly, Section 7 of this form talks about if there is a special assessment. They talk about the amount that's levied, so the amount that is payable, the date that it's due, and the amount that has been unpaid, or the amount that has passed due. So in those cases, because that's going to be something that comes up as part of a real estate transaction, and that can cause a lot of grief if it's not filled out correctly. You want to be abundantly clear as to how much is owed, when it's owed, and who has, and if it's been paid at this point. So be very careful about that. My comment being, this is the easy first step to make an incoming owner very angry if all of a sudden they show up to find out that there's several thousands of dollars that are due and payable because the previous owner, it wasn't disclosed as part of an estoppel certificate. From there, so Section 8 through 11 talks about the reserve fund study and report. 8 talks about if it's a conversion unit, which doesn't happen in a lot of cases, but if it does, you have to have a reserve fund study included. 9 talks about the qualifications of the person who provided the reserve fund study, which again should be a big challenge. It's usually found right in the reserve fund study report in itself. There's a declaration under number 10 that just basically denotes that there is no conflict of interest in the person that did the report. And then we get to 11, which is that the corporation has adopted a funding plan in conformity with the recommendations of the reserve fund study report. If yes, provide particulars of compliance. These reserve fund study reports have usually 3 different funding scenarios that they list within their contents. So it is helpful and probably technically correct if you indicate which of the funding scenarios you are following and how much money that means on an annual basis that you are purporting to collect. So it might be that they all kind of get to the same outcome. They usually just deal with how much of a percentage increase they're dealing with on an annual basis. So maybe the first year on version 1, it's 5% increases, and you're doing 5% increases every year for the next 25 years. Version 2 is like 100% increase right off the bat, and then no further changes after that. And then maybe 3 is 30% increase right off the bat, then 10% after 5 years, another 10%. Those are the kind of things that that you would want to denote in your estoppel certificate, as we're following scenario 2. We are collecting $30,000 a year, and that's what we need in order to comply with the recommendations of the reserve fund study. Make sure that once you are looking at your reserve fund study a report, that you understand what it's actually telling you to collect. So, for example, we see it all the time where there will be, we think the base recommendation of what you should be collecting is $70,000 a year. So collect $70,000 a year on a go-forward basis. And then the next line underneath is, but you are so far behind right now that you need to collect another $20,000 to catch up for where you've come from. And the recommendations of the report is based on not 70, but 70 plus 20. So if you are not collecting 90,000 in that scenario, then at that point you're not complying with the recommendations of the reserve fund study report. And so if that's the case, you need to then indicate that you're not following and provide some particulars as to why. You have no obligation under the Condominium Property Act to follow the reserve fund study report. It is kind of to be considered as part of your overall recommendation. It can create some problems for people who are buying into a unit or into a building, because sometimes mortgage instructions will say things like, lawyer is to confirm that they are funding kind of the amount in accordance with the recommendations of the reserve fund study report. So at times that might cause some grief, but it's not technically required under the legislation. So if you are in a situation where you know, you're 3 years into your reserve fund and you're doing better than you anticipated, and you want to you decide to collect maybe slightly less, or you don't do the staggered increases as suggested, that's okay. You just need to make sure that you're clear about that as part of your estoppel certificate. Okay. I note these two things. Do you have the right items, including a reserve fund study and talking about Bearline condos? I'm going to talk a little bit about that when I talk about the reserve fund study a little bit later as well. I just need 2 seconds here, guys, to just take a quick break. I'll be back in about a minute. Sorry about that. Okay. From there, we get through section 12 through 15, which talk about the financial statements. So a lot of this stuff is pretty simple information. Things like, you know, the date of the last audit or review, confirming that you know, you have the recent copy of the financial statements and a copy of the budget at whatever fee. The one that you should be aware of is just this section 13. So with it, it indicates since the date of the last audited or reviewed financial statements of the corporation, there has been no material change in the assets or liabilities of the corporation except as follows. And then there's a big blank. This is one of those sections that if you've had a pretty big discovery in terms of the financial health of your organization, that it's probably worthwhile to consider what you need to do to disclose it. You know, I think part of that would be something like, you know, if you had knowledge of a massive repair, or if you had some theft that had occurred, or, you know, some issues with an amount receivable that you would have thought that you would have had through condo fees that you ended up not being able to collect for whatever reason. You'd probably want to include any number of those details in this section, and probably with the support of legal advice if you thought it was that material that you needed to consider its inclusion. Okay. 16 through 20, largely, again, pretty simple section. I say that, but you know, parking is often, you know, one of those areas that are probably the most confused for condo corporations. So I think a lot of places are struggling with kind of how to use this document, or how to kind of limit their exposure with some of these things. So section 16 says the type of parking with the unit pursuant to section 11 of the Condominium Property Act is, and then 3 check boxes. 1, it's not required to be provided under this section. 2, it's an exclusive use parking space, or it's a parking unit. Now, the challenge with this section is a couple of things. 1, a lot of condos will use some combination of these, so they may have an exclusive use common, or exclusive use common property parking spot. They may have some parking units that are also part of it, or they may have kind of an old style where there was never a requirement for parking, and then at some point they've either adopted a parking plan through their corporation or otherwise registered something against the title. So you should have some sense of what that is. If you don't, or if there's problems with that structure, you should probably delineate that as part of this section. And if it's a real problem area, you probably want to get some advice specifically on how to word that part of it. The other challenge is that it's not uncommon for units to have kind of one parking spot that is included by a connection on the condo plan or a connection on the title, but also then to own other units associated with the parking generally, right? Like, so they might have bought a spot after the fact, and so they have 2 parking spots, and you're only noting 1 because that's the only one that you're aware of that's connected to the unit. I think that's still technically correct. It's the right way to describe it, but sometimes it can create challenges if people are thinking that there should be another parking spot and they want it noted on the Estoppel. I would guess probably technically the way to approach that would be to issue an Estoppel for the parking unit, and do it that way, but I've never seen it that way, to be perfectly honest. So you could include maybe a separate note that would say, the unit owner also owns parking spot, blah, 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 but it is not connected to the unit. Then it's up to them and to their realtor to make sure that they connect that piece to the deal that they're contemplating. 17 and beyond is talking about if there's other units that are available for rent or purchase, which is fine. 18 talks about if there's any other exclusive use areas. Exclusive use areas are denoted in 2 spots. Exclusive use areas are either on your plan. So in your plan, there'll be some specific comments as to what exclusive use areas are connected to a unit. Also, sometimes that you can pass them through kind of a special resolution. The Act has kind of a certain super priority, I think, that needs to be passed with it. But usually, if you do that, it's found as part of your bylaws. So it's possible that maybe you've got some storage areas or something that you've allocated to each of your individual units that wasn't on the plan but otherwise became available. That would be somewhere that you'd put it, and if that was the case, you'd want to make sure that you include some of that detail in the Estoppel certificate. It asks about if there's other monthly charges for the use of the parking spaces, units, and the like. You'd want to indicate that under 19. And then 20 asks about any further particulars of the parking or any exclusive use areas, including any special rules regarding those areas. That's probably an unfair statement to include in your Estoppel certificate. I think probably what I've seen that's managed at best is if you've got kind of a specific restrictions in use section in your bylaws that deal with kind of your use of exclusive use spaces, to note that in the Estoppel certificate. So, see section 32 of the bylaws for any restrictions on this, or if you've got specific parking policies that implement some of your bylaws, again, it'd be helpful to refer to those and include those as part of the Estoppel package. '21 through 26 is standard unit description, insurance bylaws, and sectors. Again, most of this stuff ends up being pretty well filled out. In the area of the standard unit description, you should know whether or not you've got a standard unit description. Standard unit description is a specific document that's passed by the condo corporation or is in existence at the time that the plan was issued, that states kind of what to the standard to which the condo corporation is insuring each individual unit. It doesn't necessarily need to be the as-built unit. It's just that standard that you're insuring up to, and it's important for people who are buying into the property to understand what their responsibility is to insure beyond the standard unit description. So you should include that so they understand A, what the corporation's responsibility is, and B, what their responsibility is. Second is just the insurance certificate. With that, you need to include, all the basic stuff: who the carrier is, the agent, the amount of the insurance, the renewal date, any additional endorsements, or the deductible. Most commonly, what we see is people just kind of providing the certificate and some of the very high-level details associated with each of those policies. I think if you had something that would be unique to your condo corporation about the insurance, or that maybe is of some form of special benefit, it would be a helpful piece to include that in that section of the Estoppel certificate. 24 asks about the bylaws. Specifically, it says the Condominium Corporation continues to operate under the standard bylaws provided by the regulations. Most condos these days do not operate by that, at least in the city. If not, attach a copy of the current bylaws is what 24 says, and then 25 it says that the bylaws and policies are in good standing, and the most recent bylaws are filed with the director. Under the Act, your bylaws are not in effect until they are filed with the director. So it is an important task to get them filed and to deal with any deficiencies that the director notes if you try to file them. It is not uncommon to run into rejection notices with the filing of bylaws. I find that corporations branch kind of their application of the rules to kind of what triggers a rejection is a little inconsistent in terms of what they see in terms of the bylaws that are being filed. When I've asked about it, they've pointed to, there's a provincial publication that talks about, what you could include in the bylaws. And there's a list of about 6 or 7 things that they say you're not allowed to include in bylaws. So comments around, proxies that are in existence for too long, fines. If you have fine language in your bylaw that you're going to impose a fine, that may trigger a rejection. If you've got age restrictions in your condo as a bylaw, often those that can trigger a rejection. So, be aware that that's a possibility and try to manage that as part of once you get kind of that reply back from the director confirming what is included and what is not included. What else? Oh, and then sectors. There's not a lot of condos that there with sectors. Sectors are kind of a specific subset of units that may have their own budget or rules. And so what that means is like, if you've got a condo corporation that has some residential units and some commercial units, so you've got, like that on Broad Street, there's the subway and lobby and all that thing. I think that's all condos at the bottom and top. The top are residential units. So with that, what you'd want to do is often to create a sector where you would kind of say there's different rules or there are different budgets or the like associated with the use of kind of these 5 commercial units versus the difference that's happening with the residential units up top. Again, there's kind of a process to put those bylaws in place. There's a process to get them recognized. And if you've got them, you should know about them and you should probably be disclosing them as part of your Estoppel certificate. I've got a question asking about bungalow condos with individual garages and driveways which are part of the common area. Should driveways be designated as exclusive use in 18? It depends on, I'd have to see the plan to really know if they're not exclusive use common property, they probably should be. It might be that sometimes when it was registered, they'll note that the driveway that's attached to the unit is considered kind of exclusive use on property. They might show that on the plan. They might have something on the bylaws. If you don't have any of those, then yeah, it probably makes some sense to at least delineate it as part of your bylaws. I would suspect that you're not going to probably have an issue with people parking into other people's driveways, but who knows? Condo owners sometimes can be a little bit of an interesting lot. So I guess, yeah, it would be a good idea to clarify it. Section 27 to 30 agreements. Generally speaking, no one cares unless you've got something unusual in those agreements. Everyone's got usually some form of garbage contract or an elevator maintenance contract or a property management contract. Sometimes we'll see kind of special energy contracts that exist. And we don't see very many short-term rental agreements, although if you have one, that probably would be of interest to people just to know kind of what's coming and going. What you probably people would also want to know about is if there's a shared amenities agreement with surrounding corporations. So for example, I've seen it where you've got one corporation that has the gym on their parcel, and then kind of some of the surrounding condos have an agreement to use that gym and to share the costs associated with it. Or similarly, if there's like access agreements, so sometimes you'll have a condo corporation that's on one side and they have a road that kind of connects to the main roadway, and then the next condo corporation next to it has the right to use that roadway as well. It's good just to advise people as to what's going on and why they may have some additional costs in a neighboring condo that they have to contribute to because of the nature of how the development had been built up in the first place. Yeah, that's those 31 through 34. That is the meetings and other proceedings. I almost always get the annual general meeting minutes. I don't always get the board meeting minutes. I think I talk about that a little bit later. But the other details here, they ask about the date of the last AGM, the date of the next AGM. If you have it, for the most part, you're going to include it. You're also largely going to include on section 34 the most recent copy of the annual return. I think another one that's easy to ignore because it almost never happens, but if it does happen, you absolutely need to disclose it, is section 35. And section 35 says, the corporation has not been served with a notice of any unsatisfied judgment against the corporation, any existing orders or actions or proceedings pending against or affecting the corporation before or issued by any court or any public authority having jurisdiction. So if you're in the middle of some form of conflict or suit, which has some public proceedings associated with it, you may have an obligation to disclose it there. That again can be a bit of a trigger in terms of, especially lenders, they don't like to be involved in condo corporations that might be in the middle of getting sued. So just make sure that is clear in terms of how whether you fit the requirements of that section, and if you do, to make sure that you're very clearly and detailed, providing kind of what is included as part of that issue. 36 is another area that I think probably gets ignored because there's a lot of stuff on here that you're not going to run into in a lot of cases. So they talk about 36A is talking about kind of transferring or leasing common property other than parking spots or exclusive use areas to individual units. So like if maybe a condo corporation has some open space somewhere and it's deciding to try to lease it to create a building for commercial venture, or a parking lot or something like that, you'd want to make sure that you disclose it. But B and D really are the areas that I think you're going to run into it more than the others. So if there's any sort of substantial change or addition to the common facility services unit or other assets of the corporation, or D, to amend the bylaws of the corporation as constituted pursuant to the Condominium Property Act. So you are, to qualify for the section, you have not taken any action or hasn't received any notice of pending proceedings. So I think that taken any action is a pretty broad type of language. So if you're in the midst of amending bylaws, I don't think there's any harm in saying, the corporation has commenced the process by which to amend the bylaws on kind of these subjects. If you've got a draft that's been circulated to your unit owners, include that draft as part of the documents that you have provided. And then that way people buying into the place will have some knowledge of what the issues are that they're running into. And then the last two things, like creating sectors, appointment of an administrator, like that's a pretty extreme circumstance. We've seen that just recently in Saskatchewan. There was a condo development that about a month ago got an order of the court creating an administrator because it was in such rough shape. And then lastly, to terminate the condominium status of the land and the buildings constituting condominium property of the corporation. Again, that's what was going on in that administrator situation, is that the property had fallen to such disrepair that they removed the condominium status and were selling it as an entity all by itself. Moving along through the remainder of the Estoppel certificate, want to know 37, if there's a property manager, if so, who are they? That's almost never filled out wrong, mainly because your property managers are usually the ones who are filling it out, so it would be a bad sign if they did. The restrictions in common property usage, I don't see a lot of detail in that. I think what it's really intended to be is probably in that situation where you've got like mixed residential and commercial usage, and maybe there's a section of the commercial space that they don't want the residential tenants to have access to because it doesn't relate to their use as residential unit owners, or maybe they've got kind of a special lift or a special service elevator or ramp or something like that. So for all those reasons, you would want to make that pretty clear. The section could be, used to describe areas that are managed or time restricted or obvious exclusive use areas like parking or decks. I think those last two, it would, if you wanted to be really detailed, it'd be an area that you could throw it in. I don't know that I necessarily would. But it's something to think about if it's something that you feel people should be aware of certain types of restrictions, that would be the place to do it. Section 39, condo owns real estate. I've seen this in very, very limited circumstances. Sometimes there's maybe a title to an adjoining space, and they've decided to buy that parcel or they have ownership of that parcel so that they can have a roadway somewhere or access to some other spot. That would be probably the only times that I've really seen that in particular. And then 40 is a pretty key one. It talks about the construction of common property, common facilities, and services unit is complete. And if so, then you don't need to attach anything. If it is not, then you need to include a copy of the developer's declaration or reservation to the condo. So what happens is when you're creating a condo development, one of the requirements of the province is that you have to get a certificate from an architect. And the architect says, or an engineer or something else, appraiser, I think. And the certificate says, well, we've looked at the plan. We understand that the following common improvements have to be made as part of this development. So we need, we need sewer, we need light standards, we need roadways, we need curbing, whatever it may be. And if that stuff hasn't been done at the time that they want to create titles, the developer has to post a bond to deal with ensuring that security is in place to finish those improvements. So in a situation where there's a lot still to be done, there could be a pretty substantial bond or letter of credit that's registered with it to make sure that work gets completed. Sometimes, especially in these condo developments where, they thought they were going to sell a lot and they only get through maybe 20 of 100 units, and then this thing kind of drags on from there out. It could be that you have, as a group of unit owners, taken over the board and you're still kind of managing you're still managing your condo corporation as you should, but the developer's security is still properly in place, and you still need to disclose it to potential purchasers going forward. And so that registration would be just right on the title. You probably would have received a copy of it at the time that you bought the place, but it's just important to continue to share that along so that a new purchaser would be aware of what kind of security was present. Section 41, final inspection reports by the local authority. These are one of those things that I don't see very often. I think I've seen it once or twice where they've actually got a report that details zoning requirements and building and fire code requirements. I've heard of people trying to pursue it, and no one's ever asked me to do it. And I don't know that I don't know how challenging it would be or not be. I know that I've had some clients that have gone to try to find it, and depending on, I think, probably the time at which the development was made, they've had some very mixed results in terms of tracking it down. I think some have been, once they put a little energy into it, have tracked it down with relative ease. Others who have put a lot of energy into it couldn't find anything. So I'm not really certain as to what the city's records have in terms of some of those details, or what the difference is over time, but it would be something that you could check out if you wanted to obtain it and share that information. Unit factors apportionment. This is another kind of important one that I think often gets glossed over. You're supposed to indicate on 42 whether or not the unit factors amongst the units included in the condominium plan have been apportioned for each unit by the approximate area of that unit. So, if you've got 10,000 square feet and you've got 10,000 unit factors, you've got a 300 square foot condo, I'm just using whatever numbers, then they should have 300 unit factors if you're doing it in proportion to their square footage. That is kind of the default that would be the expectation. There are situations where that's not the case. So I would say probably the ones where I've seen it the most would be bareland condos, because they may have a lot more square footage than some of their neighboring units, but because the livable space is determined by the lot size, then it doesn't make a lot of sense to have a disproportionately large amount of unit factors and thus cost that unit that development is supposed to take on, without so you wouldn't want to allocate it based on unit factors based on that determination. So the developer at times will see it where the developer will say, okay, yeah, maybe this corner, Bearland lot is twice as big as everyone else's, but because it would have the impact of them having double the condo fees of everyone else, we're just going to change it so that everyone has the same number of unit factors, despite the fact that the square footage is the same. If you were in that second scenario and you've got a differing type of unit factor apportionment, you are required to disclose it as part of that form. The easiest way to probably figure this out is just to look at your condo plan. They usually have it on there, that the square footage per unit. If that doesn't kind of proportionally connect to how many unit factors you've got, then it probably isn't, you're probably not set up that way for 42. Section 43 is the Estoppel certificate. Is kind of a catch-all area for the individual unit that you were issuing the Estoppel certificate for. So the corporation is not aware of any material default by the present owner of the unit in fulfilling any of the owner's obligations arising from membership of the corporation and ownership of the unit that would impact the future owner's obligation and enjoyment of the unit, except as noted above on this Estoppel certificate or noted below. So this is a big catch-all section that if you've got some sort of weird issue with this very specific unit, that you need to note it on this. So if you are aware of any encroachments into the common property, so they've built an add-on or something that they weren't authorized to do or that the plan doesn't denote, you'd probably want to include that. If they're using it in a way that's inconsistent with what their obligations were under the bylaws, any of those kind of details that that you want the future owner to be aware of, because you don't want to be responsible for the liability that some of them would create, then that's the point that you'd want to absolutely disclose to them. Okay. That is, yeah, the Estoppel certificate as a whole. So those are kind of all the major areas of the Estoppel certificate that you want to consider as you are drafting it or as you're reviewing it. You know, I don't know what the process has been with property management about kind of reviewing the Estoppel or updating it as it comes from time to time. With some of these issues, but it's something to think about as to what is your governance process to ensure that when you've got one of these issues that are being triggered, that kind of any future Estoppel certificates would reflect that until whatever that issue has changed. So, you know, consider that as part of your board. If you've going through a series of bylaw changes, you know, have you said to your property manager, oh, hey, make sure that you've included, you know, on section whatever that that we're in the middle of making changes to the bylaws, and we need to note that for the Estoppel. For the remaining documents, that's what kind of the remainder of this presentation ends up being. I've kind of highlighted, you know, what's the requirement. So obviously to provide the current filed bylaws, the value of that is to understand some of the rules around governance and the responsibilities and the use of the condominium corporation and the unit and the assets of that condo corporation. This is probably the area that the bylaws tend to be the area that most unit owners give, or buyers, I should say, give the most attention to. They want to consider probably first off the restrictions in use. Those things tend to have, you know, they're just growing all the time. I think it's easier to add than to draft in kind of an efficient way. Kind of what your restrictions in use are. I would encourage people, if you're going through a bylaw revision process, to kind of look through those with some detail and consider if there are in fact restrictions that reflect what the norms are of your condo corporation. Maintenance and repair obligations. So maintenance and repair obligations often give me the most stress as a condo lawyer and as a real estate lawyer, because I think often they don't reflect the legal requirements of who is responsible for what, or at least they're not drafted in a way that cover it in the way that they should be. And my reason for that is, when you're looking at repair, I think people get confused in a couple of ways. I think they get confused in terms of their authority of what they can impose repair restrictions on. I think they get confused about the difference between the duty to insure and the duty to repair. And then I think at times they just don't put their mind to it at all. When you're dealing with condos, unit owners have a responsibility to maintain their units. The condo corporation has a responsibility to maintain common property. There's a way that you can impose common property on unit owners and units on condo corporations. To impose maintenance and repair obligations from the unit onto the condo corporation, you have to pass a bylaw, and the bylaw has to say we're going to maintain the following parts of the unit. It doesn't have to be that specific, but it has to denote kind of that somewhere that they're going to maintain elements of what the unit is. The example that is most commonly included in is bare land condos. So in bare land condos, you have kind of a chunk of land that looks almost like a subdivision, and everything on that chunk of land is the unit owners. It is really important with bare land condos to be abundantly clear with what their maintenance obligations are through their bylaws. So you want to look and revise your bylaws to reflect if you are maintaining, for example, the exterior of the building on the unit, because generally speaking, if you don't have that bylaw, you shouldn't be maintaining it, and that includes the roof. And you say, well, but Mark, we're supposed to be insuring the roof, and you are supposed to be insuring the roof, but you have no obligation to maintain the roof. even though the fact that it's shared between any number of units, unless you've got it in that bylaw section. So that's the big thing, is to make sure that your bylaws reflect what your practices actually are. The reverse, in terms of imposing repair and maintenance obligations on unit owners from the common property, you have to designate it as exclusive use common property. And then at that point, a unit owner can be required to maintain aspects of the common property if it's exclusive use. Most commonly, we see this with, like basement or balconies and decks. And even then, we see it as more of like an ongoing, like tidying and painting kind of obligation, or a general upkeep, not a structural thing that would come along with it, obviously. So again, make sure that those details are very clear in your bylaws. Other areas of concern: duties of owners. So generally just kind of to let people know what they can and can't do associated with a condo corporation. I think a lot of the stuff in there is pretty common sense. I think the one things that we run into are people not appreciating things like, oh, well, why does this condo corporation need to have a key to my place? And that's maybe just a lack of appreciation of the nature of condo corporations. But those are the things that tend to trigger people, I would say, if I'm reviewing it with potential purchasers. Also, outdated or unnecessary bylaws. If you've got big sections in your bylaws dealing with the rights of the developer, and you have been a condo corporation for 20 years, you probably can get those things out of there. Or alternatively, if you haven't updated them in that time frame, there's probably things that you're missing, or things that could improve your governance overall that you haven't yet considered or done to include. So it's something that I definitely look for when I'm looking through these packages to see what exactly is included. Financial information. As a lawyer in that circumstance, I tend not to review the financials in any great detail. I don't have I've had some financial training, but I don't give opinions or advice in the area in kind of the same way that I would a kind of a legal issue. That said, there's still some pretty obvious things that you can run into problems with the financials of a corporation. I look at highlighting if there's significant debt or receivables or deficits that are happening within a condo corporation, as at least a trigger to say you've got some risk here, or there's a likelihood that condo fees are going up, or something like that. Also, often in the audited financials, there may be some value in looking at the notes of the condo corporation and disclosing kind of what some of the challenges are that specific condo corporation is facing. Board and AGM minutes. Again, I get AGM minutes all the time. They're usually kind of as recent as they can be. I really appreciate seeing draft AGM minutes or draft board minutes, because I think it is more important to me as someone advising someone who's about to buy it, that I have information that might be 90 or 95% correct or reviewed, that I can at least ask some questions about, than it is to have the completely finalized minutes. So it's more important for recency than it is for accuracy when it's dealing with that small level of correction that would come along with it. And I think you're going to run into more problems by not disclosing current information than you are going to be disclosing kind of moderately or minorly incorrect information. AGM and board minutes are important for a couple of really big things. One is the personality of the condominium. So, most of the fun, like drama of a condo corporation, will be captured in your minutes and in your AGM minutes. So if you've got big conflicts that are happening, or you've got kind of a consistent either maintenance problem or person problem or pet problem, that all tends to show itself out, especially if you're looking at a year of minutes that come along with it. So be aware of that. I mean, I think as a condo corporation, you should be drafting this stuff intentionally to reflect accurately what's going on, but also it's probably not necessary to include, in some cases, the large detail of drama that is happening. I think that kind of level of detail will give people pause if they're reviewing it to say, what's the problem with this condo corporation? I don't want you to hide it, but I don't think like a 2-page summary of the conflict that Bill and Jim are having over, whether or not to buy the brand new snowblower is necessary either. So, consider that. What's sufficient detail is or is it too much detail? The other piece that you're going to run into is big projects. So are there any big projects that you haven't disclosed in the Estoppel certificate, but you can tell that the writing's on the wall that something's coming down the pipe, right? So you've got, all of a sudden you're talking to an engineer about a foundation issue, or you've got a roof issue. That's where I start looking at some of those details and at least being able to ask them the questions about what you're going to run into on a go-forward basis if it is disclosed in the Estoppel certificate. Again, if it's in the minutes, you may want to be more advanced in terms of disclosing it otherwise, so that it's kind of front and center, that people are aware of it. But again, get advice on that if it's especially a contentious issue or a project that you're considering. What else? If you're in the midst of certain policy discussions or bylaw discussions or anything like that, consider if you need to include in your Estoppel package copies of those draft resolutions or bylaws. You probably don't have an obligation to do it, but I think it's a good governance practice to advise kind of an incoming purchaser as to what changes are going to be made as part of those bylaw documents, especially if it's important stuff. If it's, you're changing an interest rate or you're changing a lending authority or something like that, maybe not so important, but, you're changing a smoking bylaw or you're dealing with pets in a different way, make sure to include that so they're aware of it. And if it impacts their decision, they've had the opportunity to be advised of it. Reserve fund study, like I said before, be clear about which one you're using. Am I using scenario 1? Am I using scenario 2? Am I using scenario 3? To be aware of kind of the catch-up components or the ordinary contributions. Are you collecting kind of what it's telling you to collect by virtue of that reserve fund? I would say in terms of something that would be incredibly helpful, I think both to show that you are in control of the maintenance obligations of the corporation, and also for a new purchaser to be aware of what they're coming into, is to look at the reserve fund study and the schedule in there that denotes kind of what they're projecting in terms of improvements, and to do kind of a comparison piece associated with it. Especially if it's like a reserve fund that's 2 or 3 years old, it would be incredibly helpful to have some of these details. So if you've got a roof replacement, for example, that's supposed to be happening in 2 years as per the reserve fund study, but it actually happened a year after the reserve fund study was done, your reserve fund study is going to show or look like there's a major repair that's still to come, and you have several hundreds of $1,000s less than what you're supposed to have for this major repair that's coming. The marketing on that, when I look at it, I say, hey, look, like you guys, the condo corporation is about $300,000 less than where it should be, and you got this big repair that's coming down in a couple of years. If nothing else has happened, and we haven't seen anything that would suggest that this has been something that's been sped up, you might have a special assessment that's coming down the pipe sooner than later. So if you have something on there that would give a clear indication as to where you find yourself relative to the reserve fund study, that would be incredibly helpful for potential purchasers. Also, interest. I think interest, depending on how much of a component of your reserve fund study it is, because to be perfectly honest, I haven't seen many in the city that are getting either huge amounts of interest or have enough that it's going to compound in a material way. But more often than not, whatever you're projected to get in your reserve fund, we are getting considerably less in actual fact, and it would be helpful to know that as part of the discussion as well. Insurance certificates. With that, your requirement to provide the certificate covering coverage, et cetera, et cetera. It's important to confirm that the property is adequately and necessarily insured. The only thought on that is whether or not there's enough insurance. If you have done an insurance appraisal recently and and you've got something that would, either some sort of confirmation or otherwise that you could attach to the insurance certificate that would denote that you have adequate insurance for the property. I think that would help calm some nerves of people who want to know whether or not there's enough in place. So just something to think about. Leveling up the Estoppel package. So just things that I think would help generally. One, I'm seeing more and more kind of electronic documents from property managers. I think to get Estoppel packages, from a Dropbox or Google Drive or even just a thumb drive, it makes a big difference for all parties because they can share all the documents a lot simpler. You do have to be aware of the risk, though, of online collection and storage. I note there that there is some options in terms of maybe some integration with online forms if you're going to start, asking for a bunch of information from your incoming unit owners. Maybe it makes sense to do some of those things, especially if you're a large enough condo development. Just something to think about, I think, on that front. With the online collection and storage, I was participating in a national a condo conference a couple months ago, and there was some issues out east with one of the online document providers that ended up getting hacked and having ransomware, and no one had insurance in order to recover a lot of the documents that were found in the cloud. So, making sure that you've got backups and making sure potentially that you have the right kinds of insurance if you do have that kind of intrusion is an important thing to consider as part of your overall information gathering processes. I know that it'd be helpful to have kind of a repair and maintenance plan. So that's kind of what I was talking about before. But, if you've got, I like to see when I'm looking at the stuff, condo corporations that are clearly in control of both the repairs that they anticipate that need to be done in the short and medium term, and a real clear plan as to how they're going to fund those things. And I think as part of your annual budgeting process, it would be very helpful for you to go and look at that and say, what is our reserve fund study at? Where are we supposed to be at? What is the reserve fund study saying that is projected to be, happening in the next year or two? Do we see that as kind of a cost that we're expecting? If so, what are the costs of trying to go get some of this stuff done? And maybe you can't get that because of kind of the inflationary space that we find ourselves in. But it would be something at least to note that you're aware of it and kind of aware as to where your reserve fund study is relative to where it should be. Governance and delegation authority. My only comment on that is, a couple of comments. One, often have property management that's signing off on the Estoppel certificates. What I am not clear, and I've never asked the question, is whether or not condo corporations are passing kind of necessary resolutions to allow for the property manager to do that on their behalf, because the use of the seal should be authorized but as a corporate resolution. I don't know if there's any description between the property manager and between the board as to, who's going to provide what information about some of those things and who's liable if there is something incorrect that's provided on some of those details. But that would be something that I would say is an important piece of kind of governance and the delegation of the authority that you'd want spelled out in pretty clear detail. And then lastly, just organized and consistent documents. I see so many different condo documents, Estoppel packages that are just such a, I see some that are amazing and they're really well organized and they're clean and they're put together in a really great way. And then, we'll get another set where it's literally just like, shove everything into the Estoppel folder, and then when the lawyer needs it, we're just going to ship them whatever all this stuff is and hope that some of it sticks. Again, given that this is kind of the potential purchaser, which is the new unit owner, first look at some of these at kind of what their condo corporation is all about. They can be really important in terms of setting some of that initial image of how well it's managed and how well the board of director has kind of managing the affairs of the condo corporation. So that would be my push, is to take some time to make sure that that's reflective of your condo corporation and what you want to share with the potential purchaser. I think last is just general questions, comments, and then I guess just my it's always good to have a little bit of a pitch for some potential business. If you guys have any interest in having me go through these and giving you a more detailed report and having an opportunity to do a bit of an Estoppel review with you, I'd be happy to talk about kind of fixed cost to doing something like that and to provide some form of report. So it'd be help, go through minutes and Estoppel documents and all those things, and to come back with what I'm seeing as deficiencies in the certificate that you create. Also, I recognize that the cost of legal services can be a bit daunting or challenging or expensive, and sometimes that's just the way it has to be given the type of work that's done. But I think there's also some opportunities for maybe a more consistent fee arrangement that can happen on kind of a fixed basis that could give you some advice on a general kind of ongoing rate. So it's something to consider if it was something that would be of some value to you guys. And then similarly, if you just generally have some needs that your board would like to talk about, feel free to reach out to me directly, and I'd be happy to talk about what some of those options might be. If you have questions, I see one in the chat. I'm going to open that up. Notes, does the Corp have to have the scheme of apportionment in their bylaws? The section of the regulations note that it has to be passed by like a supermajority of 75%. I don't think it necessarily has to be included in the bylaws. I'm going to say that, and let me just go to that section 1 second. No point guessing if I can just find the answer. Oh no, actually it does. So I'll just go back to this. Okay, 1 second. So on the scheme of apportionment, section 48 of the bylaws, it notes corporation may establish a scheme of apportionment for owners' contributions to the common expense fund or reserve fund that is not in proportion to the unit factors by amending the bylaws of the corporation to include that scheme of apportionment and by filing those bylaws with the director. So yes, it is a bylaw amendment that you have to do in order to include a scheme of apportionment. You can feel free. Oh, Sharon, I think you've got your hand up. If you want to unmute yourself, I think you're able to do so. I'm happy to have you ask a question.
My question is about section 64 of the Act, 64.2, which says that deny matters that you've put into an Estoppel certificate. And I understand you can't lie about the condo fees sort of thing, but can you just expand on what would happen if sort of an honest mistake is made and you want to correct that?
Well, the reason the like 64.2, what the intention is of that section is not to, like, if you can correct it in a time where you say, let's say they haven't removed conditions from the deal, and all of a sudden you say, oh, by the way, we made an error, here's an Estoppel certificate changing things. Just be aware of this before you remove those conditions. I think you've probably done the best that you can. If you're a year later and they bought the place and it's important enough to the process that would impact their buying decision or how they would have proceeded with the transaction, then, I mean, very intentionally, you were stopped from saying to the contrary, right? So if all of a sudden, the most obvious example would be, there's no special assessment that's due against this condo. And then all of a sudden they get into their property and they're like, well, actually, there was a $10,000 one that we kind of missed. Be oopsie, here's a new Estoppel certificate. That wouldn't fly. You would then be required to go and you wouldn't be able to collect against that specific unit owner. I suspect, depending on whose role it was to manage those things, there could be some liability that would be reflective of that, but it would depend kind of on the individual circumstances of how that Estoppel certificate was generated.
Okay, thank you. That's great.
Mark, it's
Yes.
Cheryl Barber.
Yes.
Can you hear?
Yeah.
Should policies be included in the Estoppel certificate?
Yeah, I think they should. Again, big point of clarity that I like to make over and over and over again. Bylaws are the only thing that you can enforce against an individual unit owner. However, policies are basically interpretive guides of those bylaws. So, if you've got a pet policy, you make sure that you have a pet bylaw first. But if you have the right kind of pet bylaw that says, hey, you can't have a pet, subject to the approval of the board of directors, and then you have a pet policy that says, these are the types of dogs that we accept, and this is the process, and this is what you have to do, and if these are the problems that you're going to have, by all means include that piece so that people have better information about what they should be expecting when they are buying a unit. But make sure that first part's in place. I see that there was a question about draft minutes. Often I get, I used to, and I think it's probably less now, where people would, I'd ask for the most recent copy of minutes, especially AGM minutes. And they'd say, and they give me like something from 2 years ago. And I say, well, like, you must have had an AGM since then. Oh, we did, but we haven't approved the AGM minutes yet. So, well, that's fine, but like, how much value is there going to be to a potential purchaser to see something from 2 years ago about what the status is of the corporation? So my suggestion to you is, I think the risk of, like, I think you see it as one type of risk, which is, it hasn't been approved, thus it's not a representation of what the intentions were of the meeting, and thus if we share this information without it being approved, then potentially there's some harm that could be created if we've written something down incorrectly without the acknowledgement of the unit owners. I think probably the more important part of that is the second piece of that, which is the recency of that information. If you don't have information from a year ago because the Condo Corporation isn't including minutes that are in draft, then I think there's a bigger risk that you're not going to inform your potential purchaser of something that happened at AGM than having something that was incorrect. Any other questions?
Mark, this is Elizabeth McGee. That was my question about the draft minutes that you were just talking to there. So if the minutes of any of the meetings have been approved, in our case, we destroy the draft minutes. And so what we would have would be the final approved copy.
Yeah, and I guess my point being is it's probably more of an issue with an AGM than it is with board minutes, because you're probably having your board meetings more regularly than once a year. But if you were to say, like, Mark, what would be your recommendation in terms of providing minutes that are very clearly denoted as draft versus not including them at all and only having the meeting prior? my suggestion would be to have the draft minutes. So at least there's something there. Now, if that's not consistent with your governance processes, you know, I can respect that, and I can see why that would be a thing. But I think the risk is probably more with not having the draft minutes.
So if the AGM were held in December and we didn't have another meeting, because at the following general meeting, we would approve the minutes of the AGM. Yeah. So if in the interim, we were required to fill out an Estoppel certificate, then we could provide the draft of the AGM minutes, clearly identifying it as a draft unapproved copy. Correct?
Yeah, that's right. That's what I would do, is include it in that fashion.
Thank you.
I got a question about whether meeting minutes should be redacted when included in the Estoppel. I think generally speaking, I think there's a bit of a tightrope with that. I think people sometimes don't like to see that, you know, unit X is in the middle of having some issues around, you know, they're in arrears with their condo fees, or they're not doing something that they should. But I think there's some very valuable information in connecting the behavior to the unit, or the issue to the unit. So that might be a drafting thing in terms of, you know, don't say, you know, Frank Smith is doing X, Y, and Z, but you may want to say, you know, unit owner from unit 76 is, we've got arrears of this amount, or whatever the case may be. I think I would be very careful around how I would redact and what information I would omit.
Mark, it's Marlene Stanicky. We do have a unit up for sale. We had an AGM and the minutes were not approved. So I didn't give them the unapproved minutes. But what I did tell her is what had been passed, because that wasn't going to change. Our budget was passed and a few other things. And I told her as soon as they are approved, I would give them to her. Is that better than not giving a draft?
Yeah, I mean, I think everyone will have kind of their own process with it. I would just say I wouldn't encourage people to have, you know, AGM minutes that are 2 years old because of the lack of approval. Because normally what we see is AGM minutes getting approved at the subsequent AGM. Because it's a reflection of what the unit owners have decided, not so much the directors, right? So it is not uncommon at times to have kind of AGM minutes that are years old that have only been approved in draft. And so, you know, from that, I would, I think you could do it a couple of ways. You could do it exactly as you denote, or you could provide a copy of the agenda. You could provide a copy of the reports that were provided at that AGM. I think that the draft minutes is probably a more simplified version, or a simplified summary document of what happened at that meeting without it confirming the outcomes. Like I think what is the importance of those minutes? Well, probably to prove that certain outcomes had occurred. You know, if a resolution has been passed, but that's kind of what you're talking about already, is that you've confirmed that those kinds of resolutions have been passed. Usually what we're running into as part of amendments to those minutes are maybe details around, you know, who approved certain things, or who the unit owner was in this case, who made a specific comment, not substantively a change to what the overall meeting was all about. So I think, like I said, that I think if you've done it that way, I don't think there's anything necessarily wrong with it. Just in terms of what I would do to share information, I would probably include draft minutes that were clearly denoted as such.
Okay. I just didn't think legally we were allowed to give them if they weren't approved.
I think it's more, like I said, it's more about information. understanding what they're looking at. And what they're looking at is a draft copy of the minutes, that they would get a copy of those minutes if they were unit owners. There's nothing necessarily, it's not a legal issue in the concept of like, the resolution. I'm trying to figure out how I would describe this to you. The approved minutes are the legal record of what happened at the meeting. But if it's the same concept, if you had just shared with them a copy of the president's report, the president's report is a summary document that would have been provided to them that gives them information as to what the happenings are at the condo corporation. So in my mind, your draft AGM minutes are quite akin to that. It's a summary document that tells you, based on some information in a draft basis, what has happened as part of that meeting.
Okay.
When an owner being in arrears being confidential information, I don't know that it is. I mean, I can't see any reason why, especially in the context of communal spaces or living arrangements where you've got an obligation to each other, that it is unfair to share that one unit owner is behind in terms of what they're supposed to pay. You know, it is, you are reporting to the group based on what arrears are in place. You will remove individuals' voting rights based on if they're in arrears. So there's enough implications there that say that the fact that someone has not paid their condo fees is public knowledge, or should be kind of involved in the public discussion, that I don't think it would be confidential in that kind of concept. Like, you're not going to go to an AGM and say, well, Jim's not allowed to vote, but I'm not telling you why. He's just not allowed. Any other questions?
Mark, it's Cheryl Barber again. If the purchase doesn't go through and the Estoppel information is out there and provided to the real estate agent through the real estate agent, should you be getting that back?
No. I mean, you are required to provide that Estoppel to those who have an authority to collect it. And I think I'd have to go back to the regulations. I think it's kind of any relevant or interested party, maybe be just an owner. I can't remember exactly. I'll track that down. But I mean, that's all part of kind of the public disclosure that's being provided to a potential purchaser. And there's nothing that says a unit owner can't have a copy of that. That information often gets shared with financial institutions as part of their financing decision. It gets out there and it's shared. There's a very public piece to it's intentionally a public piece in terms of the Estoppel and its use. Okay, guys, well, I think I'm right at that 7:30 mark, so I'm going to call it there. But if you have any other questions, feel free to reach out to me directly. Yeah, I think this was good. I hope it was useful. I plan on having these probably every couple of months. And so if you're registered, I'll make sure to include you in kind of a notice of that at some point in time in the future. And again, if there's anything I can do to help you on a professional advice standpoint, feel free to reach out. I will make sure to circulate this presentation and the PowerPoint slides to everyone after the presentation is done, probably in the next couple of days. I've got to convert a few things and then I'll get it shipped off. But that's it. Thanks, everybody.